Hey guys, it's Adam Johnson. I'm one of the partners here at the Johnson firm, and I'm here seated next to Andy Leonards, who's one of our associates. A little background on Andy. Andy was a state trooper for like approximately 20 years. Yeah. Went back to law school, finished #1 in his class, and then came to work for us. Interned with us for a little bit, and then came to work for us. And the reason we're coming to you today with this video is because we've got sort of a major update as it relates to driver's license law in Louisiana. Andy, tell us, prior to this recent ruling from the Third Circuit, which was brought about by none other than your hard work, how was the DMV interpreting license law in the state of Louisiana with respect to that ignition interlock?
So the DMV was pretty much just taking it if you're arrested for DWI, and you refused to submit to the breath test, and later weren't convicted of DWI, that if you wanted to get your driver's license reinstated, you would have to go to one of these interlock vendors and have an interlock device installed on the vehicle for a minimum of 6 months.
Okay, so hold on. So even though you're arrested, you timely file the license appeal paperwork within that 30-day deadline we've talked about on other videos, right?
Mm-hmm. That's correct.
Even though your charges are ultimately dismissed, the DMV was interpreting it as you still have to get an ignition interlock on your vehicle, even though your charges have been dismissed.
That's correct, and that's despite there's a provision of 32667, it's H1, that states clearly that if the arrest for DWI does not result in a conviction, that the license shall be immediately reinstated. Well, they were adding a caveat, immediately reinstated when you get an interlock device installed on your vehicle on that
right.
First offense.
And so the reason this is a big deal is because for the last couple of years, a lot of times people thought that if you refuse, that even if your charges are rejected, you'll still have to get an ignition interlock device,
yeah.
right?
Yeah, that's what it was.
That's what they were being told. That's not the law. That's not true. And isn't it also true, we were sort of challenging that with respect to the administrative law side on the civil side, and some of the administrative judges were hearing it our way, and other ones were not.
And that's correct, and the ones that were finding how we believe the law should be enforced, and how the Third Circuit ultimately found as well. We would have conversations when the hearing was kind of over, and that their argument was, how we believe that, hey, there's no conviction here. It's a pending suspension. It's a proposed suspension.
Right. So they sort of disagreed in-house with how it should be interpreted. Right. But not all the administrative law judges were interpreting it the right way, right?
Yeah, half one way, half the other.
Right. So now, thanks to you taking it up, you writing this brief, you filing it with the Third Circuit has now said, hey, this is the way this has to be interpreted. And the way the law works in the state of Louisiana, all right, it means that the Third Circuit's decision, which is directly on point, will control the law statewide so long as the DMV doesn't take it up to the Supreme Court and get it overturned. Now, this DMV's deadline to file what's called a writ of certiorari with the Louisiana Supreme Court, all right, is July 7th. All right, so how quickly you see this video, all right, we're not going to release it until after July 7th because we want to make sure that they don't take that appeal. But word is that they're not going to file an appeal. And if that's the case, we're going to go back. We're going to be really happy to share that, hey, look, this is the way it should be. If you refuse, you have the right not to give evidence against yourself. That's a fundamental right. And so when you are penalized for refusing to provide evidence against yourself, but ultimately you're not convicted of any crime, that's a problem. See, the government shouldn't be able to punish you if we're not able to prove you did anything wrong. They ought not be able to just punish you for not blowing on their machine, just like they can't punish you for not giving a statement against yourself. So this returns us back, all right, to the way the law was rightfully supposed to be determined, right, and supposed to be sort of interpreted. This returns us back to that and alleviates any doubt,
and then
right?
To know this was not a decision that I believe that they just thought lightly of. They gave an 18-page written ruling, very extensive, going through their thought process, and for every argument that, hey, you had to install this on the vehicle, and that they didn't have to reinstate their driver's license. They met those arguments with law.
Yeah, with legal interpretation saying why the state had it wrong.
And it was a very, it mirrored, what I wrote, but it shows that they took this under heavy consideration.
Yeah, right. It's not a bad opinion. It's very, very thorough. We think it'll absolutely hold. And we think that's also the reason the DMV is probably not going to take it up to the Supreme Court, is because they have very little, if any, chance of getting it overturned. So in any event, we're happy to do that. The reason we're happy to do that is because, well, I mean, it's the Johnson firm. Truly, leadership, proven leadership, and a trusted name. This is that leadership stuff that we talk about. Because not only does this affect our clients positively, but this affects people who don't, haven't hired us. It affects them in a positive way, because again, we're talking about people whose charges have been refused and or dismissed, all right, and who are being penalized solely for refusing to blow on a machine that's not that accurate. That's important.
Also covers people that decided to take their DWI to trial, and where the judge said not guilty, or for the period of time with the juries where the 6-person jury decided, hey, the person was not guilty.
Or the judge finds them guilty of a lesser offense.
Correct.
Someone doesn't find you guilty of DWI, but finds you maybe guilty of reckless operation. The penalty for reckless operation is not you have to put an ignition interlock in your car. So it's important that this law was interpreted correctly. Yeah. And, hey, we're proud of you for getting it done.
Just the biggest caveat and the most important thing to remember, and that's what the Third Circuit had, stated, the most important thing is to file that administrative appeal within 30 days. That is kind of the key, because that's what takes a suspension in 30 days to a proposed suspension until the appeals process is
That's right.
completely
And the reason that's
vetted out.
important is because, and I think what I hear you saying is that if you refuse to blow, you're charged with the DWI. Ultimately, it's thrown out. You're found not guilty. The charges are refused. You're not even prosecuted for DWI. If you don't file that civil paperwork to challenge the suspension of your license within 30 days, even if the charges are thrown out, you can't come then back later and say, hey, give me back my license now. It should be automatically reinstated, because you have to file that appeal within 30 days or you're just agreeing to it. And so that's why we're emphasizing that point, because this ruling won't protect you if you don't file that appeal, even if the charges are dismissed. You still got to file that appeal within 30 days. That's something that we do. And those are rights that need protecting. And, by hiring the right attorney, obviously, well done, brother. That's good work.
Great win.
Yeah. Okay. All right. So that's all we have. Hopefully this was helpful, and hopefully you hear it. You see this video maybe like right after July 7th, because that means they didn't take it up. We ain't got to sit on this for another couple of months.
And y'all have a safe 4th of July.
Right.
Hey, we appreciate you watching that video. If you have other questions about other legal topics, check out our website, johnsonfirmla.com, or our YouTube page. We put out material all of the time in the areas of family law, personal injury, and criminal defense. We really appreciate you checking us out. Thanks so much.